If your will clearly states that everything goes to your spouse, but the beneficiary designation form on your $400,000 retirement account still lists your ex-wife from a marriage that ended 11 years ago, your ex-wife gets the money. Not some of it, all of it. The court will not intervene. Your spouse cannot contest it. Your attorney cannot reverse it. Your will is completely irrelevant. And this is not a hypothetical. This happens in probate courts across the United States every single week. What you are about to hear in the next 25 minutes may be the single most important financial correction you make this year. Because beneficiary designations are the most powerful documents most Americans never think about, and the most catastrophic when they are wrong. Here is exactly what we are going to cover. First, we will explain what beneficiary designations are and why they legally override every other document in your estate plan, including your will and your trust. Second, we will go through the 5 account types where beneficiary designations control the transfer of wealth and what happens when each one is wrong. Third, we will walk through the 6 most devastating beneficiary designation mistakes we see in estate planning, including the one that forces your retirement accounts through probate and costs your heirs up to 40% of the account value in taxes. Fourth, we will cover the per stirpes versus per capita election and why this one checkbox determines whether your grandchildren inherit anything at all if your child predeceases you. Fifth, we will go through the Secure Act 10-year rule and what it means for the people you leave your IRA to. And sixth, we will walk through a complete beneficiary audit checklist, the exact process for reviewing and correcting every account you own before a mistake becomes permanent. I am Marcus Webb, and this is Benefits Decoded. I work exclusively in estate planning and retirement wealth protection. Every year, my team reviews hundreds of estate plans, and without exception, the most common and most expensive errors we find are not in the will, they are not in the trust, they are on a one-page beneficiary designation form that was filled out decades ago and never reviewed again. To understand exactly how this works, I want you to meet Robert. Robert was 67 years old. He was a structural engineer who spent 34 years working for a large civil infrastructure firm in Ohio. He was careful, methodical, and responsible, exactly the kind of person who did everything right. He had a will prepared by an attorney. He had a revocable living trust. He had a healthcare power of attorney. He had a durable financial power of attorney. His estate plan was, by every measure, complete. Robert was also divorced. His first marriage ended in 2008, after 19 years. He remarried in 2012. And by all accounts, his second marriage was a good one. He and his second wife, Diane, were together for 11 years before Robert passed away at 67 from a sudden cardiac event. Robert's estate plan said everything went to Diane. His trust said everything went to Diane. His will said everything went to Diane. But Robert's $420,000 traditional IRA still listed his first wife, Karen, as the sole primary beneficiary. The form had been filled out in 2004, 4 years before the divorce. It had never been updated. Karen received $420,000. Diane received nothing from that account, and there was nothing legally that anyone could do about it. Chapter 1. What beneficiary designations are and why they override everything. A beneficiary designation is a legal instruction attached directly to a financial account or insurance policy that tells the account custodian who receives that asset when you die. It operates completely outside of your will and completely outside of your trust. It does not go through probate. It does not require a court order. When you die, the custodian verifies your death certificate, verifies the identity of the named beneficiary, and transfers the asset often within weeks. This transfer mechanism is called a non-probate transfer. It bypasses the entire court system. And that is the point. It was designed to be fast, private, and automatic. The problem is that this same speed and automaticity means there is no review process. No one checks whether the form is current. No one verifies that the named beneficiary reflects your current wishes. No one cross-references the form against your will or your trust. The form controls. Full stop. Courts across the country have consistently held that a valid, signed beneficiary designation form supersedes any conflicting provision in a will or trust. This is settled law. Your attorney cannot argue around it. Your family cannot contest it on the basis of what you intended. The form you signed whenever you signed it is the controlling document. This is why beneficiary designations are simultaneously the most powerful estate planning tool available and the most dangerous when neglected. Chapter 2. The 5 account types where beneficiary designations control. There are 5 categories of accounts where beneficiary designations determine who gets what completely independent of your will. The first is retirement accounts. This includes traditional IRAs, Roth IRAs, 401k plans, 403b plans, 457 plans, SEP IRAs, and simple IRAs. In the United States, the total value of assets held in these accounts exceeds $35 trillion. For the average American household approaching retirement, the retirement account is often the single largest financial asset they own, and all of it transfers by beneficiary designation. The second is life insurance. When you die, the insurance company pays the death benefit directly to the named beneficiary on the policy. If your policy has a death benefit of $500,000 and you named your college roommate as beneficiary in 1998, your college roommate receives $500,000. Your spouse receives nothing from that policy. The third is annuities. Annuity contracts held outside of a retirement account have their own beneficiary designation that controls who receives the remaining contract value or death benefit at your death. The fourth is payable on death bank accounts. Many checking accounts, savings accounts, and certificates of deposit allow you to name a payable on death beneficiary, sometimes called a POD designation. This converts an ordinary bank account into a non-probate transfer account. At your death, the bank pays the balance directly to the named POD beneficiary. The fifth is transfer on death brokerage accounts. Standard taxable brokerage accounts can also carry a transfer on death designation, sometimes called a TOD. Like a POD bank account, this transfers the securities in the account directly to the named beneficiary without going through probate. Collectively, across all 5 of these account types, most middle-class American households have the majority of their financial wealth sitting in accounts that transfer by beneficiary designation completely independent of whatever their will or trust says. Chapter 3. The 6 most devastating beneficiary designation mistakes. Mistake number 1. The ex-spouse designation. As you saw with Robert, leaving a former spouse as a beneficiary on a retirement account is the single most common catastrophic beneficiary error in estate planning. Federal law, specifically the Employee Retirement Income Security Act, known as ERISA, requires plan administrators to pay the named beneficiary on the form, regardless of divorce. Some states have automatic revocation laws that void an ex-spouse designation on certain accounts after divorce, but these laws do not apply to federal retirement accounts governed by ERISA. Your 401k, your IRA, your SEP, those require you to update the form manually. Divorce does not do it automatically. The cost of this mistake. On a $400,000 IRA, if your ex-spouse is named and receives the funds, your current spouse receives nothing. That is a direct loss of $400,000 to your intended beneficiary. Mistake number 2, naming your estate as beneficiary. When you list your estate as the beneficiary of a retirement account, you have just sent that account through probate. This is one of the most expensive mistakes possible. Here is why. A retirement account with a named individual beneficiary transfers directly. No probate, no court, no delay. That same account with estate listed as beneficiary must go through probate court before it can be distributed. This adds months to the process and thousands of dollars in attorney and court fees. But the far bigger problem is the tax treatment. When an estate inherits a retirement account, the account must typically be fully distributed within 5 years. This forced distribution compresses all of the taxable income into a shorter window, often pushing the distributions into the highest tax brackets. On a $400,000 traditional IRA inherited by an estate rather than an individual, the difference in tax treatment can cost the heirs $60,000 or more. Mistake number 3, naming a minor child directly. If you name a minor child as the direct beneficiary of a life insurance policy or retirement account, the insurance company or custodian cannot legally pay funds to a minor. The money goes into a court-supervised custodial account. A guardian must be appointed by the court to manage the funds. That guardian must file annual accountings with the court. When the child reaches the age of majority, typically 18, they receive the entire amount in one lump sum, with no conditions and no guidance. An 18-year-old receiving $400,000 with no structure around it is not an estate plan, it is a problem. The correct approach: name a trust as the beneficiary for minor children, with a trustee who manages the funds according to your specific instructions, staggered distributions at defined ages, educational requirements, or whatever conditions you choose. Mistake number 4, no contingent beneficiary. Most beneficiary designation forms have 2 sections: primary beneficiary and contingent beneficiary. The primary beneficiary receives the asset if they survive you. The contingent beneficiary receives the asset if the primary beneficiary has already died. Most people name a primary beneficiary and leave the contingent section blank. If your primary beneficiary predeceases you and you have no contingent beneficiary named, the asset typically falls back to your estate and goes through probate. All of the speed and efficiency of the non-probate transfer is lost. Mistake number 5. Outdated percentage splits. Many people split their beneficiary designations among multiple people, 50% to each child. For example, life changes, children are born, children die, marriages happen, divorces happen. If you named 2 children as beneficiaries at 50% each, and 1 child predeceases you, what happens to their 50% share? The answer depends entirely on whether you selected per stirpes or per capita allocation, which brings us to the next critical topic. Mistake number 6, forgetting new accounts entirely. Every time you open a new retirement account, roll over an old 401k, or purchase a new life insurance policy, that new account starts with no beneficiary designated. The default is almost always your estate. People change employers, open rollover IRAs, consolidate accounts, and each time, a new blank beneficiary form is waiting to be filled out. In the chaos of a job change or account transfer, the beneficiary form is easily overlooked. Every new account is a fresh risk. Chapter 4. Per stirpes versus per capita, a single checkbox that changes everything. When you name multiple beneficiaries on an account, most forms give you a choice between 2 allocation methods, per stirpes and per capita. This is one of the least understood elections in estate planning, and it has enormous consequences. Per capita means that the asset is divided equally among your named beneficiaries who are alive at your death. If you name 3 children and 1 predeceases you, per capita means the remaining 2 children split the asset 50-50. The deceased child's share disappears, their children, your grandchildren, receive nothing from that account. Per stirpes means the asset is divided by branch of your family. If you name 3 children and 1 predeceases you, per stirpes means the deceased child's share passes down to their children, your grandchildren, in equal shares. The share does not disappear. It flows to the next generation. For most parents, per stirpes is the intended outcome, but many people check per capita without understanding the difference, or they do not check anything at all and accept the plan's default. The result is that grandchildren are unintentionally disinherited simply because a checkbox was left unchecked. Chapter 5. The Secure Act and the 10-year rule, what your heirs need to know. Before the Secure Act was passed in 2019, a non-spouse beneficiary who inherited an IRA could stretch the required minimum distributions over their own life expectancy. A child who inherited a large IRA at age 30 could take small, tax-efficient distributions over 40 or 50 years. This was called the stretch IRA strategy, and it allowed inherited retirement accounts to continue growing tax-deferred for decades. The Secure Act eliminated the stretch IRA for most non-spouse beneficiaries. Under the 10-year rule that replaced it, most beneficiaries who inherit an IRA must fully distribute the entire account within 10 years of the original owner's death. There are no annual minimum distribution requirements within those 10 years. The beneficiary can take money out at any pace, but the account must be empty by the end of year 10. The tax implication of this change is significant. A beneficiary who inherits a $500,000 traditional IRA now has 10 years to distribute it. If they are already in their peak earning years, say in their 40s or 50s, those distributions stack on top of their existing income and push them into higher tax brackets. The inherited IRA that was intended as a tax-efficient gift to a child can instead result in an effective tax rate of 32% or higher on every dollar withdrawn. Exceptions to the 10-year rule exist for what the law calls eligible designated beneficiaries. These include surviving spouses who are still entitled to roll the inherited IRA into their own IRA and take distributions based on their own life expectancy. They also include minor children of the original owner, though only until the child reaches the age of majority, at which point the 10-year clock begins. Disabled individuals and individuals who are chronically ill also qualify for the stretch, and any beneficiary who is not more than 10 years younger than the original owner qualifies for the stretch. For everyone else, adult children, grandchildren, siblings, friends, the 10-year rule applies. Understanding this rule matters when you are deciding who to name as beneficiary and when you are doing tax planning around your retirement accounts. A Roth IRA, which is distributed tax-free, is far more valuable to leave to a high-income adult child than a traditional IRA, because the mandatory 10-year distributions carry no tax cost. Directing your Roth accounts to beneficiaries who will face the 10-year rule and using your traditional accounts for charitable giving or spousal inheritance can dramatically reduce the total tax burden on your estate. Chapter 6, the complete beneficiary audit, what to do before the end of this month. Step 1, make a complete list of every account you own that carries a beneficiary designation. This means every IRA, every 401k, every life insurance policy, every annuity, every bank account with a POD designation, and every brokerage account with a TOD designation. If you are not sure whether an account has a beneficiary designation, call the institution and ask. Step 2, request the current beneficiary designation on file for every account on your list. Do not rely on memory. Do not rely on documents you signed years ago that may have been superseded. Request the actual current form on file at the institution. Step 3, compare each current designation against your current wishes and your current family situation. Check for ex-spouses. Check for deceased individuals. Check for minor children who should be redirected to a trust. Check that your contingent beneficiary is correct. Check the per stirpes versus per capita election. Step 4, update any form that does not reflect your current intentions. This is not a complex process. Most institutions allow you to update beneficiary designations online, by phone, or by completing a simple form. It takes minutes, but it must be done in writing through the institution, not in your will, not in your trust, not in a letter to your family. Step 5, coordinate your beneficiary designations with your overall estate plan. If you have a revocable living trust, discuss with your estate planning attorney whether certain accounts should name the trust as beneficiary, particularly for life insurance and for accounts that will benefit minor children. Step 6, review every 3 to 5 years and immediately after any major life event. Marriage, divorce, the birth of a child, the death of a named beneficiary, a new account, a job change, any of these is a trigger to review every beneficiary designation you have on file. Here is the bottom line. You could have the most carefully drafted will in the world. You could have a fully funded revocable living trust. You could have every power of attorney document in perfect order. And a single outdated beneficiary form can unravel years of careful planning and redirect hundreds of thousands of dollars away from the people you love. The designation form is the last word. Not your will, not your trust, not your intentions, the form. Spend 1 hour this week requesting the current beneficiary designations on every account you own. If even one of them is wrong, that 1 hour may be the most financially important hour you spend this year. If this episode helped you, please share it with someone you care about. A parent, a sibling, a friend with an old 401k, and an even older beneficiary form. Not tomorrow, today. I am Marcus Webb. Thank you for watching Benefits Decoded. Previous episodes covering what happens when you die without a will, how a revocable living trust works, and the power of attorney documents that protect you while you are still alive. All of those are linked in the description below. Take care of your family. I will see you in the next one.